Good morning, everybody. My name is Trevor Sanders. I'm an attorney here in Utah who does workers' compensation. And I'm putting another video together today that addresses a question that comes up a lot about statute of limitations and how long do I have to file. It's surprising how many times this type of question will come up in just really casual conversation for me, even when I'm not in the office. So in Utah, there's the statute of limitations kind of operates on a sliding scale, so to speak. The first statute or the first deadline really to be aware of if you've been in an accident is you've got to report your accident to your employer within 180 days. So 6 months. If you get hurt at work, you have 6 months to report that accident to your employer. Now, what constitutes a report? What is satisfactory when it comes to making a report? It doesn't have to be a formal incident report. It can be. An employer may have an incident report. They may have like forms for you to fill out, things like that. But it could be as simple as a text message or an email or a voicemail or a call. Now, in the law, every attorney will tell you they want to see paper. So I would say the same thing. You're going to want a paper trail. You should send a text message or an email or an incident report, something in writing to show or prove or establish later on, if you get there, that you did report it, that they did know about it, and maybe the employer didn't report it to their insurance carrier, they didn't take action, but at least you can show, yes, I was hurt and I reported this. So that's the first deadline, 180 days. But then here's the next question. Then what? Well, then if you have been hurt at work, you need to get medical treatment and you need to get checked out by a doctor. And the thing to keep in mind here is that medical records in a workers' compensation claim, at least here in Utah, reign supreme. They are the most important things of your case. Not so much witness testimony or comparing and contrasting of things that you could do before versus after. All of that is helpful. I'm not going to say it's not relevant or helpful, but what shows up in your medical chart, that's what the judges at the Labor Commission and the medical panels focus on and weigh very heavily when they're deciding to make an award or not to make an award of benefits in your case. So the longer in time from the time of your accident to the time you go get medical care, the longer that gap is, it's what we call a treatment gap. The longer that treatment gap is, the more problematic it becomes. And if you think about it, it's really unfair because if you get hurt at work, you're probably not going to want to make waves with your employer. You're not going to cause a ruckus. You're not going to stand up in the canoe, so to speak. You're going to go home, you're going to ice it for a couple of days, you're going to take some ibuprofen or some over-the-counter medication or whatever you've got there in the house. And then if it still isn't getting better, then usually you're going to report it, right? Some people do that and then they'll go to the doctor on their own, or they'll just try and tough it out on their own. They just don't want to make waves with their employer. And sometimes what happens is there's a gap in treatment from the date of the accident to the time that they first go to the doctor where it's mentioned in their medical chart. You could have weeks or even months. And the longer that gap is, the more problematic it becomes because the judges at the Labor Commission and the medical panel doctors tend to assume, well, if they were hurt that bad, they would have gotten treatment. And because they didn't get treatment, they must not have been hurt bad. It's not a fair presumption, but that's what happens. So that's an important thing. If you've been hurt at work, report it and get medical attention. Create a record of the fact that you were hurt at work and you sought treatment from a medical provider. As far as the rest of it goes, if you've been hurt at work, you've got a 6-year period to file something with the Labor Commission. And in some cases, it can be as long as 12 years, especially for permanent disability cases. After 12 years from your date of your accident, you're not going to be able to file a claim for lost wage benefits, permanent disability, impairment rating, those types of things. But for medical care, there's not a statute of limitations. So theoretically, you could have gotten hurt in 1992 and had a back injury, and you worked for the next 30 years, and in 2022, suddenly you need another back fusion, let's say. You're ineligible for any kind of lost wage benefits. So if you have the surgery and you uh, take time off work, or you have an increased impairment rating, something like that, you're ineligible for indemnity benefits. That's what those are called. But you still have a claim for medical benefits, assuming that a doctor will attribute the need for the current medical procedure to that underlying workers' compensation event 30 years ago. But theoretically, you still have a claim to file. So for medical care, there's not really a statute of limitations. The defense will still push back, and they'll say, hey, no, this a lot of time has gone by. They had another car accident. They've just gotten old. They have defenses. It's not going to be a slam dunk, but that doesn't mean you don't have a claim. So yeah, that's just a little tidbit of information, helpful pointers. If you like what you hear, follow me here on YouTube. Check us out at utahodvocates.com, and let me know if you have any questions. Thanks, everybody. Bye.